Welcome to Employment Bite. In this series, our London employment team provide bite-sized overviews of some of the key developments surrounding the employment law landscape in the UK. Whether you're an employer or employee, join us for a discussion navigating the dynamic world of employment law. I'm Kathy Savage, and I'm joined today by Imtiyaz Chowdhury. In the second part of our series on the Employment Rights Bill today, we're going to be discussing the proposed ban on fire and rehire and what it could mean for employers in future. So first things first, Imtiyaz, is fire and rehire a new development?
No, it's not. We used to call it dismissal and re-engagement and see it as one of the options for employers who wanted to change employees' terms and conditions of employment. Normally, employers would try to agree to changes with employees or their representatives first. During the financial crisis in 2008, for example, there were lots of examples of employers and employees agreeing to shorter working hours as a way to avoid redundancies. But if negotiations failed, employers knew that they could implement changes by dismissing and re-engaging employees on new terms. They might face unfair dismissal claims, but the new terms will be effective.
So why has this become so controversial more recently?
Really, because there were high-profile cases during the pandemic when large employers were accused of threatening employees with a sack if they didn't agree to new, typically worse, employment terms. Sometimes dismissal and re-engagement was threatened at an early stage and before there had been any proper discussion with employees or their representatives. It wasn't being used as a last resort after other routes had been pursued. Now, whatever the rights or wrongs of those cases, it fed a view that large companies were taking advantage of employees and treating them unfairly. That was turbocharged when P&O Ferries dismissed its employees without any consultation at all and hired new workers on worse terms. Now, although the Conservative government introduced some extra safeguards for employees through a code of practice, dismissing and re-engaging remained legal, to the unhappiness of trade unions, and that's led to the current proposals in the Employment Rights Bill.
Turning to those proposals now, the Employment Rights Bill makes it automatically unfair for an employer to dismiss an employee in two situations. The first is where an employee is dismissed because they've refused to agree to a variation in their contract. The second is where the employer dismisses an employee in order to re-engage the employee or employ someone else to carry out the same duties as the employee, but on new terms. So in future, a dismissal in order to make changes to employee terms and conditions will normally be automatically unfair. But there's one exception to that. Imtiyaz, can you explain it?
Yes, a dismissal will not be automatically unfair if an employer shows that it was facing really serious financial difficulties which were going to affect its ability to carry on its activities or operate as a going concern. If the employer is making changes to terms and conditions to prevent or reduce those difficulties, and it could not reasonably have avoided the need to change terms, dismissals will not be automatically unfair. That's quite a change from the current position where an employer normally just needs to show that it has good business reasons for making a change. In all honesty, I don't see the exception as being likely to apply in very many situations. Kathy, do you agree?
I do. The way it's framed certainly implies that the financial difficulties facing the business have to be serious or critical. It's definitely much more than needing to just improve business efficiency, for example. And what an employer needs to do to persuade a tribunal that it couldn't have avoided the need to change terms and conditions is very unclear. Even if the exception does apply, dismissals could still be unfair on normal principles. And on that note, the Employment Rights Bill sets out specific issues that a tribunal must consider when deciding whether an employer has acted fairly. That includes factors such as whether the employer has consulted with the employees or their representatives about the changes, or offered something in return for the variation. That could mean an improvement in some other aspect of employee terms and conditions, or a payment to buy out a benefit an employer wants to remove, for example. How does that compare with the current position?
It's only a change in the sense that it's now mandatory for tribunals to consider consultation, but that's not new from a fairness perspective. Cases already recognise that prior consultation with a recognised union or direct with employees is highly relevant to whether an employer has acted reasonably in treating an employee's failure to agree new terms as a reason to dismiss. The need to consult employees or their representatives is already a key feature of the Code of Practice on dismissal and re-engagement. So the Employment Rights Bill provision doesn't really represent a major shift. And collective redundancy consultation obligations could obviously also be engaged. Looking forward, Kathy, what are the practical implications for employers who want to change terms and conditions once the changes come into force?
As viewers will have gathered, it's going to be much harder for employers to rely on dismissal and re-engagement as a way of changing employee terms in future. Unless the exception applies, any dismissals will be automatically unfair. So employers will be liable for basic awards and for compensating dismissed employees for any financial loss. And that's even if they've accepted employment on the new terms. I'd also be concerned about employees asking for re-engagement on their previous terms as a remedy for unfair dismissal. Tribunals have ordered re-engagement in connection with TUPE-related contractual changes in the past, and we may see more employees asking for it in the future. The employer would then either have to go back to the pre-varied terms and compensate for any loss in the meantime, or face paying additional compensation if it refused to comply with the re-engagement order. So I think most employers won't think seriously about dismissing and re-engaging in future. There'll be a much greater focus on getting consent from employees or their representatives.
I agree, but I also think that we may see more attempts to rely on contractual variation clauses going forward. Contracts often include clauses allowing employers to change aspects of an employee's contract unilaterally. A mobility clause giving an employer a right to require an employee to work from a different location is an obvious example. An employer's ability to rely on a flexibility clause may be restricted in various ways. The clause itself could have limits. The mobility clause might say that the employee can only be required to move a specified distance. Employers also have to act in accordance with the duty of trust and confidence. Now, that might include giving an employee enough notice of the change or not exercising a right in a way that leads to a significant drop in earnings. But as long as the right covers the change the employer wants to make and the employer respects the duty of trust and confidence, it doesn't need the employee's consent to make the change.
And that means there's no breach of contract and no need to dismiss and re-engage.
Exactly.
I can see that approach may work where you've got a specific clause allowing the employer to change working hours, duties, or the workplace. But can employers rely on general, wide-ranging clauses that say they can change any aspect of an employee's contract? And if so, does that give employers a way round the restrictions on dismissing and re-engaging employees?
Well, that's going to be the million-dollar question, and no doubt something we're going to see tribunals considering over the next few years. Historically, tribunals and courts have been unwilling to allow an employer to rely on very general and wide-ranging flexibility clauses. Normally, they expect there to be clear language specifying the types of change the clause permits an employer to make. Any uncertainty is usually construed against the employer. And so in the absence of clear language, courts and tribunals have often found that very general amendment powers only apply to minor or administrative changes. They don't give employers a blanket right to make changes that have substantive detrimental effects for employees. Now, having said that, there's been at least one case where the Employment Appeal Tribunal allowed an employer to rely on a general amendment power to change employees' pay unilaterally, although it was a slightly unusual case on its facts. So in future, we may well see more employers including widely drafted variation powers in employment contracts and then seeking to rely on them in order to change employees' terms without the need for agreement or dismissal and re-engagement.
So a case of watch this space, Imtiyaz. That brings us to the end of today's Employment Bite. Thank you for joining us, and we'll be back with another bite in a couple of weeks. And next time, the team will be talking about the changes to collective redundancy requirements in the Employment Rights Bill and how this will affect employers.